Morning, everybody, or good afternoon, actually. We'll be starting in just a minute. All right. Good afternoon, everyone. My name is Josh Stripmatter, and I'd like to welcome you to Stripmatter's Wealth Smart Money webinar series. Thank you for joining us today. Our presentation today is titled Texas Probate, Unlocking the Secrets to a Smooth Estate Transition. For those of you that don't know us, we are Stripmatter Wealth Management Group, a registered investment advisor located in downtown Fort Worth, Texas. We specialize in investment management, financial planning, estate planning, and real estate investing. We've been in business since 2007 and serve clients throughout the United States. A little bit of housekeeping before we get started. All of you have access to your chat feature. So if you have any questions, please don't hesitate to type those in, and we're happy to answer those, today for you. Also, we'll be sending you a replay of today's webinar via email. So if you missed something, don't panic. You'll have the ability to watch this again. And you are welcome to forward this presentation and any of our presentations to your friends and family if you think it would be of benefit. Today's webinar is meant to be purely educational and not meant to be tax or legal advice. Please talk to your licensed professional before taking any action on the information in this presentation. For more information, including key disclosures, please visit our website at stripmatterwealth.com. Now let me introduce our speaker today. Her name is Monika Worsley. Monika Worsley attended Southern Methodist University School of Law, where she graduated with her law degree in 2000. Monika began her career practicing litigation and general civil law before moving on to practice estate planning and probate law. As an attorney, Monika enjoys working closely with her clients to create an estate plan that encompasses their unique family structure, plans, and goals. Beyond her legal endeavors, Monika has deep connections within the Fort Worth community, having dedicated over 2 decades of volunteer work to various charitable organizations. When she's not immersed in her legal practice, Monika cherishes quality time with her pediatrician husband, their 2 young adult children, and their large and loving extended family. Her personal interests span a wide range, including traveling, reading, playing with her dogs, musical theater, and exploring her creativity with crafts and projects. Good afternoon to you, Monika. How are you today?
Thanks, Josh. I'm doing great. I really appreciate you having me on here. So I am here to talk about probate, and I'm going to share my screen, so give me just a second. All right. We up and running?
We are up and running.
Okay. So when you hear the word probate, most people make a face something like this. So I'm not sure that most people understand everything that probate entails. A lot of people don't really know what it entails at all, but they know that they should have some fear of it. So one of the things that I'm here to do today is to demystify probate for you, maybe take some of the fear out. So let me see if I can move to the next slide, perhaps. Sorry, I am using the setup for Karen. Karen is the principal of our firm, and I'm using her setup, which is a little different from mine. So in just a moment. Okay, and Karen is on the phone with us. She actually, believe it or not, death does not avoid probate attorneys. So Karen has had a death in her extended family, her chosen family, and she is on her way now to be with the family for that. And that's one of the reasons that I'm here using her computer. So let me see if I can move on to the next slide. Okay, so before we get too deep into what probate entails, let's just talk about when someone dies, what do we do with all the stuff? So the first thing is we don't do anything. We preserve the estate until we determine if legal action is needed or not. So, you can secure the assets, but you want to do nothing. So this is where you hear about someone dying and their kids going in the house and start removing things that they want from the house. That is not supposed to happen. So nothing should be done with the property of the decedent, which means the person who's passed away, until there's a determination if legal action is needed. So just some housekeeping things, you've got to get a death certificate. And really, you can't have too many copies of that death certificate. You use them for almost everything. We recommend getting 10, 15, whatever, depending on the size of the estate. You're not going to go wrong with having 15 death certificates. It takes a couple of weeks for those death certificates to come in. While you're waiting, make an appointment with the Social Security office. That takes a few weeks too. So a lot of times people will call our office and want to get in right away because this is a very stressful time for them. Somebody has died and they want to find out what they need to do. So here's the thing, we can't really start the process of probate until we have that death certificate. So it may take 2 or 3 weeks to get that. It may take 2 or 3 weeks to get someone in for a probate consultation. But if there's any situation where you might need something done quicker, we can do some emergency proceedings. So let's talk about what that looks like. If you have family who are battling over where grandma's going to be buried or whether she's going to be cremated, that's an emergency proceeding because something has to be done very quickly with the body. And just so you know, those kind of battles can be prevented by appointing someone before you die. Appoint someone to handle the disposition of your remains, somebody who knows what you want. Even better is you can do a pre-need planning ahead of time so that there is no question as to what you want. Another situation where emergency proceedings might be warranted would be if you have animals. I mean, if you've got livestock that need to be fed and cared for, or if you have domestic animals, somebody has to take care of the cat and the dog, and the court can get involved. We can do an emergency proceeding to make sure that somebody has authority to take care of those things in advance. Okay, so just again, housekeeping before we get into probate too much is get a large notebook, put every piece of mail that comes for the decedent into that notebook and start creating lists. We need to know as we go through this process what the decedent has and what they owe. So start creating those lists, start an inventory of what they have, they're in the house, in their property, what accounts they have. You want to make sure that later there is no question that you took something or that someone took something that didn't belong to them. A lot of fights end up happening over who took what before it got into the court system. So I love this picture. The waves coming in is just a reminder that wave comes in grief, and making lists like this can help make the waves of grief manageable. Okay, so now on to whether probate is going to happen or not. So we live in an asset distribution system. Every single asset passes according to its own laws. So real estate, for example, passes via deeds. All liquid accounts have beneficiary designations or transfer on death designations. If you have an account where there is a failure of the beneficiary designation, what happens? Well, oops, that check would be written to the estate of, and then the name of the decedent. Well, that's an entity that doesn't exist until you enter the world of probate. All right. So what is probate in Texas? So probate's a judicial process of distributing the assets to the heirs of somebody who's died. So if someone has made a will, then it's going to be to the beneficiaries. If that person has not made a will, it's going to be to the heirs according to the laws of the place where you live. So in Texas, it's going to be Texas heirs. So in Tarrant County, we have statutory probate courts. We've got 2 of them. And that is who we go and file the probates with. Sorry, I got a little distracted there. Okay, so why is the probate necessary? The probate would be necessary because you can't do anything with a decedent's assets until you legally control them. So that's access to a bank account, for example. The bank will not give access to anybody who is not on that account until there are letters testamentary issued by the court in a probate process. So back to whether you have a will or not, if there's a will, then the probate proceedings that are available would be the independent administration, muniment of title, dependent administration, or a community property administration. That is rarely used now. So the sort of gold standard of a probate proceeding, the easiest one to do with a will is that if we have a will where somebody has assets and somebody has debt, they have a valid will. Sort of a simple probate process is where the court designates who's in control of the estate. The court accepts the will into probate and determines who the heirs are, and the administrator files an inventory of the decedent's asset, notifies the creditors, pays liabilities, and distributes the remaining assets to the heirs. So the terminology is a little bit different, whether you have a will or no will. So with a will, there's an executor, and that person's appointed by the will. If you have no will, there's an administrator. If there is a will, you have beneficiaries or devisees. If there's no will, then you have heirs. If there's no will, there's another person who has to get involved, and that's the attorney ad litem, who the court appoints the attorney ad litem to represent the unknown heirs and to do some investigation to make sure that the court knows who the heirs are. So again, without a will, you can have a small estate affidavit, an affidavit of heirship, a determination of heirship with or without an administration. If there is an administration, there's a determination of whether it's independent or dependent. So why is that scary? Well, it's scary. It's scary to a lot of people because at the point where the court gets involved, they feel like they lose some control. So who, what, when to probate? We already know the why, because there is property that needs to be, the court needs to say who is in charge of that property. So when someone dies, there's 4 years to probate a will, and they need to have some property in the estate. So if someone passes away and they don't have any property, no probate's necessary. Now, the only time I guess that would be a little bit different is if somebody dies and there's a lawsuit that could be filed over their death. Say they died in an accident and there's a wrongful death lawsuit that could be filed. There has to be an estate of that person in order to file that lawsuit. So that's probably the only time where someone with no assets would really need to have a probate process. Okay, we go to understanding the basic procedures for probate. So you establish which proceeding needs to be filed and who needs to file. So again, we have 4 years to probate a will from the date of death. Then there needs to be some property. So who is the person to file? Technically, it can be anyone. Typically, it would be the person named as executor in the will, or a lead administrator who the family kind of decides is the person that they want to file. But just because you're the one to initiate the process, it doesn't mean that you're in control. So the what to probate is the assets in the estate. So any real property that is titled to the decedent, business ownership. If they own, say, an LLC, that's something that would be an estate asset. Any personal property, so their furniture, their household goods, their clothing, all of that jewelry, all of that personal property that we all have, that would be a probate asset. And then any financial assets that don't pass by beneficiary. So if you didn't have a beneficiary listed or there's some failure of the beneficiary, that check would be issued to the estate of the decedent. And then again, any lawsuits that are pending, that would also be a probate asset. So determining whether there's going to be whether there's a valid will or not, it doesn't take much to have a valid will in Texas. The bar is actually pretty low. So the person who signs the will has to have had capacity, be over 18, or there's some exceptions if you're lawfully married or military. And then the document, there's two different types: holographic will and an attested will, which is the one that most of us think of. So if the will was properly done, it should name an independent executor, should name beneficiaries, has the appropriate formalities, a self-proving clause, and then at that point, it's an administrative process in Texas. So here's what that looks like. Because no one has authority to act on behalf of an estate without letters testamentary from the court, the first thing that you have to do is file an application. If there's a will, you file an application, you get the will admitted into evidence. There's a little hearing that happens, and the probate court admits the will. You have the executor appointed by the court, and the executor receives letters testamentary. And those are actual letters that the court issues that will allow that executor to go and show banks or realtors, title companies, whoever needs it. It shows that they have authority to act. And that way they can file an inventory, the notice to creditors as required under the estates code, and make distributions when it's time. Now, if the will is not properly done, then oops, there are still some ways that we can try to fix it. For example, if there might need to be additional witnesses, if there was a problem with the way that the will was drafted, or the executor might need to be a dependent instead of independent administration. Let's see. If the letters testamentary are issued and there's a will, there's a debt payment. So once the letters are issued, what you have to do, this is why you have that notebook. You gather in all of the assets and you pay the debts of the estate. So what does that debt payment look like? So we have this list of priorities that the Texas legislature has laid out for us. So class 1 claims, things like funeral costs and expenses from last illness, those get paid first, up to $15,000. And the remainder gets filed if you have a much more expensive funeral than that. The remainder would get filed as an unsecured claim. Number 2, lawyers. Expenses of administration, that includes legal fees, those get paid second. Then secured creditors, things like your mortgage, your liens, anything that's secured by an asset, those get paid next. Then child support claims, then taxes, penalties, and interest, and then claims of confinement by the Texas penal system. Then class 7, claims for repayment of medical assistance payments, and then all other payments would be made. So once all of the assets are gathered, a notice to creditors is put out. There's a certain waiting period that has to happen. And when that's done and all the debts have been paid, then the estate can finally be distributed. Okay. Sorry, I'm going a little bit too fast there. Okay. So if you die without a will, the big questions are who inherits, who controls the property, any other considerations that you might think about? Well, Texas law controls. Texas has a plan for you, even if you don't have a plan for yourself. And that plan may not be what you want. So the process, if you die without a will, is still called probate, but it happens a little bit differently. There's an heirship that happens, a determination of heirship. So the process is still similar. You file an application, an attorney ad litem has to be appointed to determine who the heirs are. The ad litem does that investigation, they file a report, and then there's a hearing where the administrator is appointed by the court, and they receive letters administration. Those letters administration, again, allow that administrator to act on behalf of the estate. Now, if it is a independent administration, they have a little more freedom. If it's a dependent administration, they have to basically go in and ask the court every time they want to do something. And that, as you can imagine, gets a little bit expensive because they go in there with their attorney and they're paying for that time. So problems with the heirship, people sometimes think, well, I'm married to my first wife. We have 2 children. The state of Texas would leave everything to her first and then to the kids. So why even bother having a will? Well, the problem is it can be very expensive to do it with that method rather than just having a will and keeping things simple and an independent administration. Also, there can be some unintended consequences. So sometimes the probate process can be more difficult, definitely more expensive. It can include or exclude the wrong heirs. So there may be somebody who you want to make sure does not get anything. And because of where that person is in relation to you in the lineup that Texas has for heirs, they may end up getting something that you never wanted them to have. It can be a little hairy. There are charts and lists, and I'm not going to get into the weeds with what the Texas statutes lay out for heirs, but it just goes to show you why people want to avoid probate. One big thing is the time that it takes. So it takes anywhere from 3 months to a year, sometimes longer. If it's contested, it can go on for years sometimes. So things that you would want to think about are, what would you do now? Say the heirs need cash now to preserve the estate. If they need to sell the house now to get the best market. So, a year ago, the market was really great. Right now, it's not that great. So you would want them to have the ability to sell the house when the market is good and not to be stuck waiting to get all of this taken care of in the probate court. The expense for an uncontested probate, it can be anywhere from $1,500 to $5,000 and up. So you also have to pay for an ad litem attorney if one has to be appointed. And in Tarrant County, I think it's $400. Other counties, it's more. It can range up to like $800 in a county, I think in Houston. There can be huge hourly fees for contested matters. And then you have to think about things like if you have, let's say, a rental property, you've got a vacation home, you've got a little cabin in another state, and let's say you have a fishing cabin in Louisiana, then you not only have a probate in Texas, you also have to have a probate, an ancillary probate in Louisiana, hire another attorney for that. It can get really expensive really fast. There are also privacy concerns. So once that will is admitted to probate, what happens is it becomes public record. So some people don't mind about that, but some people care very deeply about that. It may have private information about your family in the will, and then an inventory, if it's filed, tells the world what was in the estate, and the will says who inherits it. The creditor claims that get it, well, we don't typically file those, but basically there's a lot of information that could get filed in the probate that you may not want to be public for whatever reason. If nothing else, because you don't want somebody knowing that grandma just left you a whole bunch of money or a house, and then suddenly you're getting calls from brokers trying to see if you want to sell it. The other thing is timing. After somebody you love dies, it's the worst possible time to have to deal with all of this. There's grief, there's stress, there may be tension between you and the other family members. Something may need to be done very quickly. And unfortunately, in the probate process, nothing is super quick. Again, 3 months is a little bit of a pipe dream. We do have some great courts. The statutory probate courts get things moving as quickly as they can. They keep their dockets pretty clear, but you still have to wait till you can get a hearing and get all of those steps done. So, of course, what can an attorney provide? Surprise, surprise, attorney doing the presentation. I'm going to tell you, going with an attorney is the best way to get things as smooth as possible, but we can make sure that the will is clear ahead of time. We can make sure it has all of the proper formalities, everything that it needs, and that we think through every worst case scenario possible, and we plan for it in your documents. We can make sure that your estate planning goals are met and that it matches up with your assets. All of that makes probate faster, easier, and cheaper. And then we also can offer you some alternatives to completely avoid probate if at all possible. Things like trusts, things like transfer on death deeds, things like joint tenants with right of survivorship on your accounts, and talk you through the beneficiary designations and why that's important. So there are on those avoidance techniques, things like if you're not too worried about probate, you can have a will-based estate plan, but you can partially avoid probate or possibly entirely avoid probate with things like have a transfer on death deed that leaves your property upon your death to the person or persons that you want. Revisit your beneficiary designations on all of your liquid assets pretty regularly. Make sure that those are updated. And not only that, that if possible, have a first beneficiary and then have an alternate beneficiary. And that way, if there's a problem with the first, it can drop to the second, which then keeps that out of probate. But also make sure that that beneficiary designation matches up to what you want for your estate plan. So as an example, if a woman has, she has $500,000 estate, just to have round numbers, she makes a will, leaves all of her money in equal shares to her 3 daughters. But one of the daughters lives closer and helps take care of her. And so that lady went ahead and put her daughter on the account as joint tenants with right of survivorship. That account has about $100,000 of her $500,000 in it. So what she didn't understand is that when she dies, her daughter gets that money, that she drops off the account and the daughter just stays on. So that money doesn't go through probate. Daughter number 1 gets that. And so then when it comes to the probate assets, those would be divided a third, a third, a third. And so the way that it ends up is the daughter number 1 who is on that account gets a share that was larger than what mom had planned on. So that can cause fights in the family. It may not be what mom wanted, but that's a good reason to look at it with your lawyer. Let them talk through it with you to make sure that your plan, including your beneficiary designations, matches up with your wishes. So we definitely think you should review your will, your distribution plan, your beneficiary designations with an estate planning attorney. Make sure there's no conflicts, no contradictions, so that when you go through this probate planning process, it's as inexpensive as possible and as easy as possible for you, or best of all, that we can completely avoid it either with a will-based plan and some good planning with alternates, or with a trust-based plan, which will keep you out of probate. So for your sake and the sake of your loved ones, you definitely want to have a will, and you definitely want to talk with your attorney and have it reviewed, as well as reviewing all of your beneficiary designations regularly. And that is all I've got for you today. So I'm going to turn it back over to Josh.
All right. Thank you, Monica. Great job. We will take some questions. If y'all would like to just type them into the chat, we'll be happy to answer those questions. And let me share my screen. Give me one moment here. So again, if you have any questions, just type them in. And I have a question for you, Monica. So how many people in Texas, you may not know this, die without a will?
Oh, I don't actually know. I don't have the data on that.
You think it's a
Just
large
based on,
percentage, or do you think most people have wills?
yep. Karen's on the phone with us too, and
yeah, we actually just had a seminar yesterday and they talked a little bit about this issue. It's 68%
Oh, wow.
people die without a will, and they were talking about Texas. And so, yeah, it's a pretty significant number.
Yeah.
And a lot of probate work because of that, but certainly that can be prevented.
Oh, yeah. Well, I was interested in that statistic because I think that all the things that you talked about today are reasons why you'd want to have a will. And I know it's not that difficult to put one in place, having gone through the process myself, and certainly worked with lots of clients to help them to help get that done. So, you know, and that's probably a good question, is in, you know, putting in your estate planning documents, what would you gauge from a standpoint of time from the client's perspective? How long does it typically take to do that?
to get your estate planning documents in place.
Yeah.
So typically when we get the phone call from somebody saying, hey, our amazing wealth managers sent us your way to get our estate plan in place, we'll set up a consultation we send a packet. We try to keep that packet very small, just some very simple basics. It's 2 pages front and back. When we set up the consultation, it takes about an hour. We talk through a lot of the things that are on that sheet, which is basically the makeup of your family, your wishes for your property, and then we talk about fiduciaries, who you want to be in charge of what after you die. So based on those things, we can kind of make a plan. From there, maybe 2 weeks, that's sort of what we shoot for in terms of drafting the documents. It sometimes is as long as 3. If things are busy over here, if there's a holiday, but we really try to get that turned around pretty fast for people, send drafts back out, have you look at them. And then once that's done, we set up a signing. And when you come in, we have you review things one last time, answer any questions. Then we bring in a notary, the 2 witnesses, and we walk through the signing of all those documents. So start to finish, you're probably looking at, you can have it done in a month. Yeah,
Yeah.
for sure in a month, sometimes even shorter. We get people who want to do it really quickly because they realize they're going out of town in 2
Right.
weeks, or sometimes people are having a big surgery that was unexpected.
Sure.
And when that happens, we do everything we can to get them in fast and get those documents in place.
Sure. Yeah. And then how often do you think they should revisit those documents?
Well, for sure, probably a minimum of every 3 to 5 years. Your beneficiary designations and your estate plan should be looked at again, but also if there's any big thing that happens in your life, if there's a divorce, if there's a death, if there's a birth, it's a great time. You celebrate those things, you cry together over those things, and then you should just take a breath and look at your estate plan and make sure it still makes sense with what you want.
Sure. In working with clients over the years, I think one of the biggest obstacles for them is finding somebody who could serve in that role of executor or executrix. What do you do when you don't have anybody?
That's a great question. And it's come up a lot recently. I feel like it's come up a lot more just in the last few months than it really ever has before. There are corporate fiduciaries who will actually serve in those roles. And, it's for some people, even if they have family who would do an okay job of it, but they just don't want to leave that pressure or stress on them, and especially in the role of something long-term, like taking care of trust for kids who are young, who are going to be needing that money for a long time. The corporate fiduciary is a great option. They're bound by the terms of the trust. They are bonded, so there's no, if they don't follow it, they will, but if they don't, there is a great avenue for litigation where money can be returned to that trust. And then they just really know what they're doing, and they have great resources, CPAs, lawyers, real estate agents, whatever. They have access to all of the professionals.
And is that a trustee, or are you specifically, or can they serve as executor for the will?
So you can have an attorney serve as executor for the will. Karen, can you answer that as to, I'm actually for the corporate fiduciary.
Yeah, I can certainly address that issue. That's a great question. So as an executor under the will, we've had to do that on a few occasions, be named as executor the law firm has, but then also some of the smaller trust companies that we deal with, they will act as executor, so that when you have a larger bank like Bank of America or Chase, they want estate assets, the probate assets themselves, typically over 5 million before they'll even look at it. I've had Chase and some of these other big banks named and absolutely declined to serve in that position, because it's important to know that no matter who you list, even if you haven't had a thorough conversation with them, nobody has to serve in these fiduciary positions if they don't want to. There's no forced servitude. So, but as a trustee in a trust or as an executor of a will, when they have nobody, either a law firm or a small trust company like Argent Trust or Bank of Texas has a good trust department as well, Sierra Bank, and I'm sure, Josh, you work with a few too.
Yeah, we do.
Yeah.
Okay, so that sounds like the solution then. So that shouldn't be a reason why you don't get your documents completed, right?
Correct. Absolutely not.
Okay.
There's a remedy for everything.
Absolutely. Well, very good. Well, I don't know that we have any more questions.
The only other thing I would add is that the importance of having a will isn't just because you get to name the beneficiaries that you want to protect your legacy. It's also because in these days of 23andMe and Ancestry.com, we find members of our family that we didn't know existed. And
Yeah.
so these surprises are something that can be completely avoided if you list out who the beneficiaries should be of your estate in your will and trust documents. And so that's the only other thing I wanted to add, is because in an heirship determination proceeding, we find people that families never even knew of, and it's becoming more common. And so that can be avoided by having a good plan in place.
Very interesting. Yeah. I keep hearing stories about long lost relatives meeting each other. So yeah, well, very good. Well, thank you both. And we appreciate the information. And listen, if you have any questions, folks, you're welcome to give us a call at that number there. Shoot us an email. We also have their information as well that we can forward on to you if you would like to talk to them directly. But other than that, thank you so much. I hope everybody has a wonderful day.
Thank you
Thank
for having us.
You bet. Bye-bye.